how do we begin to ask the right questions here? If we can't know for sure what the right answers are, how do we frame the questions? And this is why, by the way, we have an instructor program here at Law Self Defense, because I've taken my share and more of firearms instructor courses, firearms classes, CCW classes, and there's often a point at which the instructor starts getting to the legal aspects of use of force. Often it's required for a CCW licensing course. And really, it just means he starts reading statutory language to the class, which is completely lacking in context, not very actionable. And when the class asks the instructor questions like, well, would I be allowed to shoot if this happened or that happened? The instructor not only can't answer the questions, probably shouldn't provide a definitive answer, right? He's not a lawyer, and even a lawyer shouldn't really provide a definitive answer to a hypothetical, because small changes in facts result in big changes in legal outcomes. But he can't even provide a framework for understanding what the right questions should be. Well, the most important issues in that hypothetical would be these three. That's what you'd want to focus on. That doesn't need to be the case. In my opinion, anyone teaching any kind of use of force law should have a sufficient grasp of use of force law to at least be able to frame out what the questions should be, so people know what facts to look for. That's kind of what we'll be doing here today. So how do we do that? Well, of course, the questions are all a reflection of the required elements of a claim of self-defense, the 5 elements of a claim of self-defense. By the way, you can get that little elements of self-defense cheat sheet I just held up for free. We give it away for free right there on the screen. lawofselfdefense.com/elements for the 5 elements of self-defense lists them and provides a brief description. If you don't understand those 5 elements, you can't possibly understand defense of yourself or defense of others, defense of persons law. And those 5 elements are innocence, imminence, proportionality, avoidance, and reasonableness. And they are the building blocks of any claim of defense of persons, and they're cumulative. So if any one of those elements can be disproven beyond a reasonable doubt, your entire claim of self-defense justification or defense of others collapses. So each of these becomes effectively a target for attack by the prosecution. He knows he doesn't have to disprove them all. He only has to disprove any one required element. Now, sometimes there aren't 5 elements. 5 is the most. And that's great news, right? There's not 500 elements to a claim of self-defense. There's not 50. There's not that much you have to remember as a defender. There's only up to 5, and often not even 5. Like one of these, for example, is the element of avoidance. Avoidance has to do with whether or not there's a legal duty to retreat before you can use deadly force in self-defense. But the truth is, there's only 11 states that require this element of avoidance in an otherwise lawful case of self-defense. 39 states do not have a generalized legal duty to retreat before you can defend yourself in an otherwise lawful case of self-defense. So in those 39 states, in an otherwise lawful case of self-defense, there aren't 5 elements. There's only 4, because avoidance is taken off the table. Sometimes in defense of highly defensible property scenarios, like defense of your home against an intruder, it's possible for 4 of the 5 elements to be legally presumed to have been satisfied. That's pretty good, right? In any case, the most you have to worry about is 5. So let's take a look at those 5 in the context of this use of force event. In fact, let's start out of sequence with avoidance, because New York is one of the 11 states that is a duty to retreat state. So under New York law, you have a generalized legal duty to retreat before you can use deadly force in self-defense. If retreat is possible with complete safety. If it's possible with complete safety. So those are 2 conditions on your legal duty to retreat in New York State and any other state that imposes this legal duty. It has to be practically possible. Retreat has to be feasible. You can't have a legal duty to do something that's impossible to do. And it has to be possible to do with complete safety. You're not required to increase your jeopardy in an effort to retreat. So someone swinging a machete at you, if turning your back would increase your jeopardy, turning your back in an effort to retreat would increase your jeopardy, the legal duty doesn't apply. If someone is threatening you with a gun, you can't outrun a bullet. So attempting to retreat from an aggressor threatening you with a gun, not practically, not possible with complete safety. In this scenario, of course, we have the gentleman with the gun is on his back. What's the completely safe avenue of retreat here before the use of deadly force? So you're not firing the gun. You're attempting to satisfy New York State's legal duty to retreat before you can use deadly force in self-defense. First, is it practically possible? Well, no. It's not practically possible before the aggressor would be able to inflict further harm on you. That's the question. The aggressor here is standing immediately over the shooter on his back. I'm going to call him the shooter, even though we don't know that he fired the shot, just as an easy way to describe him. So there is no possibility of retreat here, and there's no possibility of doing it with complete safety, other than, of course, by firing the gun. That means even under New York State law, New York State, which has a generalized legal duty to retreat, this particular fact scenario would not require this shooter to attempt to retreat before he could lawfully defend himself with deadly force, assuming the other elements of self-defense are satisfied. Just because you may be relieved of a legal duty to retreat doesn't necessarily mean you're justified in shooting, right? You can be relieved of a legal duty to retreat, relieved of this element of avoidance, but the other 4 elements still apply in order for your use of deadly force to be legally justified. If you violate one of those other 4, well, then you lose self-defense because you lost one of those other elements, even though your failure to retreat by itself didn't cost you self-defense. You committed some other additional error that did cost you self-defense. The point is, when we look for weaknesses in this shooter's legal justification for the use of deadly force, the element of avoidance is not likely to be a viable target of attack for the prosecution, because you can't practically and with complete safety attempt to retreat when you've already been knocked on your back. And remember, this guy standing over him struck him in the face and neck in some form. Struck him in the face and neck.